Hello again, everyone. Welcome to Washington Gun Law TV. I am Washington Gun Law President William Kirk. Thanks for joining us. Illinois, we're going to need to talk again. Your legislature is back in session, which is never, ever a good thing. And I don't normally get to follow the Illinois state legislature as closely as I'd like because I have my own state legislature to keep an eye on here in Washington, and they are completely screwed up 6 ways to Sunday. What got me going down this rabbit hole was some social media posts about a new piece of legislation kicking around that would require your doctors to ask you questions related to firearm ownership. Really, really weird. Not sure what that has to do with your cholesterol, your blood sugar, your body mass index, or anything like that. And so I decided to start really searching around on the Illinois legislative website, see what other bills are kicking around out there, because usually where there's smoke, there's a lot more fire somewhere else. And lo and behold, we're going to connect 2 bills for you today. 2 bills that once again show that when it comes to gun laws, by far the most evil, nefarious, and sinister gun laws in America always come from the state of Illinois. So today, let's spend a few minutes, let's get you educated about 2 bills, and let's talk about how Illinois wants to use your doctor to disarm you.
Well, and just to give people the type of understanding of the financial catastrophic occurrence that occurred, you and I are both privy to people who have been involved in lawful self-defense situations, pulled the trigger with legal justification, faced potential legal consequences, and had to fight for their freedom. Didn't have coverage. How much money did it cost them to win their freedom?
You know, I really don't think that people really can grasp, the magnitude of expenses. Most recently, and you and I have talked about this in the past, the Kyle Rittenhouse case brought a lot to light.
Right to bear, that's right. Legal protection for self-protection. Listen, good lawyers aren't cheap. Cheap lawyers aren't good. You're not truly prepared unless you have right to bear back you. You will always get an attorney-answered hotline, so you will always have a confidential phone call. There are no cap limits for either civil or criminal defense. This covers all forms of self-defense. So from a fist to a firearm, from a fat lip to a dead body, you are covered, and you will have some of the nation's most passionate 2A attorneys in your corner fighting for you. And right now, if you visit my friends at protectwithbear.com and you use the promo code WGL, you will receive 10% off. Listen, you need to protect yourself so that you can protect them. Visit my good friends at protectwithbear.com. Okay, Illinois, what we're going to be talking about today is connecting the dots on 2 separate pieces of proposed legislation. One is House Bill 1398, which we'll start with, and then the other one's going to be House Bill 2526. Now, 1398 is the one that kind of got me going down this rabbit hole, but I knew that, hey, I see some smoke here, there's fire somewhere else, and I think I have found that fire. When I say at the very beginning of this video, hey, Illinois, they're going to try to use your doctors to disarm you, this is exactly what I think is going to happen. So when we take a look at House Bill 1398, what it is doing, it is going to mandate new requirements of pediatricians. The bill as written, if enacted into law then, would read as follows. Gun safe storage. Pediatricians. The department shall ensure that pediatricians ask about the presence of guns in homes and distribute safe gun storage information to individuals with guns who reside in a home with a child. Okay, so what that means is when you're taking your kid to the doctor, that pediatrician now will be mandated by state law to ask you questions about the presence of firearms and their storage conditions. Now, nothing in this particular law mandates that you answer those questions, and that certainly could be one way of dealing with it. And for those of you who geek out on the channel regularly, you'll know that this is not a particularly unique idea. It's been proposed in other states, and we have always encouraged people, as we did in this video right here, that, hey, listen, unless they're asking about what your diet has been, how much you've been drinking, what's up with your cholesterol, what's up with your blood sugar, things like that, there really is no reason to be answering questions to your doctor that is not related to your medical care. So I got to thinking there, like, okay, so why do they want all of these doctors to find out about the presence of firearms and their storage conditions? Because they don't want that just for data. I mean, maybe some states would, but this is Illinois. Illinois is absolutely positively going to want to use this to their advantage, or what we like to call civilian disarmament. So I kicked around there on the Illinois State Legislative website, and lo and behold, we got House Bill 2526, which is going to amend your firearms restraining orders, red flag laws, extreme risk protection orders. Everyone's got different nomenclature for it, but they're essentially red flag laws. Currently as it sits, Illinois, the only people who can petition for a red flag hearing against an individual are household members, spouses, and law enforcement. Because if this bill is passed into law, there will be significant amendments to who can petition for a red flag order. And those amendments include the following. 3, any of the following healthcare professionals who have treated the person against whom the order is sought in the 6 months immediately preceding the filing of the petition. A physician licensed to practice medicine in all its branches under the Medical Practice Act of 1987. B, a psychiatrist as defined in Section 1-121 of the Mental Health and Development Disabilities Code. C, a clinical psychologist licensed under the Clinical Psychologist Licensing Act. D, a licensed social worker licensed under the Clinical Social Work and Social Work Practice Act. E, an advanced practice registered nurse, nationally certified as a mental health or psychiatric nurse practitioner and licensed under the Nurse Practice Act. Or a licensed marriage and family therapist licensed under the Marriage and Family Therapy Licensing Act. So if both of these pieces of legislation are enacted into law, understand that not only could all of your counselors and your doctors now petition for a red flag hearing, or what you guys like to call a firearms restraining order, but also your kid's doctor will be privy to that same information. And therefore, that information could theoretically be shared through other methods, because there clearly is no doctor-patient privilege here, right? Because if they're allowed to take information that you give them and then use it to get you red flagged, clearly the state is creating a situation in which that privilege is waived. And that's not unique to states like Illinois. In Washington, for example, anytime you fill out a Form 4473 or apply for a concealed pistol license, there is something right in the statute that says, hey, by the way, you're waiving all medical privileges. We can go digging around as much as we want. Illinois, what the state legislature is setting up there is a large kind of gill net that they want to throw out, and they want to get all of the medical professionals involved in this. And I'm not just talking about your doctor. I'm talking about your psychiatrist, your psychologist, your counselor, anybody like that. And then if that doesn't work, they're going to want to use your kids' doctors as well. This is probably the first in what will be many amendments to your Firearm Restraining Order Act, where you will see over the course of next several years many other categories of individuals who will be allowed to petition the court for a red flag order against you. So, Illinois, you need to very carefully watch, and we'll link them all up down below so that you can geek out on both of these, but you need to watch House Bill 1398 as well as House Bill 2526. Once again, the state of Illinois working hard, working overtime to disarm you, the lawful and responsible resident of that state. Listen, if you got any more questions about this or anything else related to what's left of your Second Amendment rights in Illinois right now, that ain't much. You guys should know how to get a hold of Washington gun law by now, but if you don't, that's okay. That information is down there in the description box. If you got an idea for a video we should be doing around here, you click on that link right there and tell us all about it. If you want to subscribe to our monthly newsletter, the ability to do all of that is down there in the description box. And then finally, and most importantly, let's everyone remember that part of being the lawful and responsible gun owner, like we talk about all the time here, is to know what the law is in every situation and how it applies to you in any instance that you may find yourself. Until next time, thanks for watching and stay safe.